A California elementary school teacher accused of showing up to work drunk was arrested, but the charges were dropped because she didn't break the law? We're going to explain with LA County Public Defender Philip Dubé. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey there, everybody. This is another Law&Crime legal alert. Have you experienced severe gastroparesis or other side effects after taking Ozempic or another GLP-1 weight loss medication? The Ozempic lawsuits allege that the drug can lead to severe intestinal blockage and persistent vomiting, and that manufacturers allegedly failed to provide adequate warnings about these risks. Well, True Law, one of our legal sponsors, is helping those injured file a claim through an experienced attorney who helps ensure your claim is thoroughly presented. Visit glp1case.com/sidebar to answer less than 10 questions and check your eligibility to file a claim. Teachers have been accused of all sorts of things, right? Being unfair, being mean, being bad. Fortunately, in cases we cover here on Sidebar, there have been teachers and educators who have been accused of being sexual predators. But I will tell you, this next teacher we're about to discuss was accused of something else. She was accused of being drunk during class. And when I say class, I mean a second grade class. According to the Sutter County Sheriff's Office back on October 2nd, 2023, then 57-year-old Wendy Munson, a second grade teacher at Nuestro Elementary School in Live Oak, which is just north of Sacramento, California, was arrested. Police received a report that Munson was intoxicated, and by the way, this was just before 8:30 in the morning. She was arrested for a potential DUI after the sheriff's office reviewed video footage of Munson driving to school where she failed a sobriety test. Now, she was initially charged with potential child endangerment, for allegedly teaching her second grade students, drunk. After all, her BAC, her blood alcohol content, was determined to be 2 times over the legal limit. But guess what? Guess what happened? The charges were dropped. Why? Well, according to the district attorney's office, it is apparently not illegal. Right. You might be shocked to hear this. So the Sutter County DA's office, in a statement, said, quote, "The mere potential that a situation could arise is insufficient to meet the requirements under the law. While teaching under the influence is highly inappropriate, it is unfortunately not illegal." Sutter County DA Jennifer Dupree followed up by saying, quote, "The behavior is reprehensible, but it doesn't violate the penal code to teach kids when they're drunk." Seems, though, that Munson is no longer listed on the school's website as a teacher, so we will see what disciplinary action results from this. But let me bring in Philip Dubé, Los Angeles County Public Defender, who's appearing in his personal capacity. Philip, great to see you. Is this true? This isn't a crime?
That's correct. The lecturer lucked out, Jesse. The way the California law is written is that you can only criminalize being under the influence in public. So, for example, had she been taking a swig from a beer bottle out in the parking lot or on the sidewalk or in the football field or somewhere like that, then that is, at a minimum, drinking in public. And that is a crime in California. But even assuming that that's what they had her on and that's what they were going to book her on, under California law, they don't put you into criminal custody for that. They bring you into civil protective custody, and they can hold you for up to 72 hours until you dry out, basically, till you sober up. And the theory is that once you have accomplished that and you don't need any additional services or help, a criminal prosecution is barred. And the reason why is that the 3 days in civil protective custody is ample punishment, if you will, to remedy that brush. So she lucked out here. They don't have her drinking in public. At most, they have her drinking in a classroom. And unfortunately, that's not a crime.
Well, let's break that down a few things. First of all, I would imagine they don't want this to escalate to full-blown court proceedings because the courts would be flooded every 5 seconds with people who were drinking in public. I'd imagine that's why. But number two, it's a school. There's kids there. This is not considered under the definition of a public place?
No. Only if it's outdoors. Once she goes into the classroom, you are no longer deemed to be in public.
Let's
That
say
is
she was
not.
drinking and they were doing outside activities in the schoolyard.
Oh, then they could hook her up and haul her in for that.
Really?
Absolutely. Because now
Okay.
she is in, yes, absolutely, they could. Yes. Now, it's not the
Okay.
crime of the century. It's drunk or drinking in
Well,
public, which obviously is reprehensible, but, it's not as if she's Ma Barker for doing
Well,
it,
you could see why people are bothered by a elementary
Yes.
school teacher being drunk. Now, some would say, how is this not child endangerment? So I looked up the California Penal Code. You obviously know it better than me, but I was looking up 273A, and it says any person who willfully causes or permits that child to be placed in a situation where his or her person or health is endangered shall be punished by imprisonment in a county jail not exceeding 1 year, or in the state prison for 2, 4, or 6 years, I guess, depending on the severity. This isn't child endangerment?
Not under California law. No, not at all. If there were reports, for example, that she was tripping over her feet, she had an unsteady gait, or that she was passing a bottle around to the kids to take a sip, that kind of thing, then obviously that's endangering their health and certainly their safety. But at most, what you have is her endangering herself. And that, unfortunately, does not meet the criteria for child endangerment. The problem, Jesse, is that the legislature needs to step in and amend our education code, because there are provisions in there that criminalize the conduct of teachers. But you know what it takes? It takes these unprecedented moves, these unprecedented acts to affect change and reform in the law. And you can
Yeah.
bet that our Assembly and State Senate will be convening to add something like this to our education code and to the penal code.
Well, because this story has been amplified. It's everywhere right now. People are wondering about it. I think people are shocked that it's not actually illegal. I guess, wouldn't it matter what kind of teacher she was? Why do I say that? I said, maybe, okay, second grade teacher, she's drunk, it's inappropriate. But if she were home ec, right? Operating machinery, or a chemistry teacher or a gym teacher, would it be different? Could it be child endangerment?
I think it could be child endangerment for purposes of her professional licensure. So, for example, it's not over for Ms. Munson. You can bet that this incident got reported to the California Commission on Teacher Credentialing. And what they will do is they will go behind the record and look to see whether or not this misconduct renders her unfit or immoral for teaching in a California classroom. So they'll go separate and apart from the criminal definition and try to see if they can maybe revoke her license on that basis. But I can tell you, based on my own independent research, they renewed her teaching credential in March of this year, and it's good for another 5 years. Now, it's not to say that she's teaching. My gut says that she worked out a deal with the district that she would quietly retire or step down, and that would be the end of the matter, and she could save her credential. Doesn't mean she'll ever be in the classroom again, but that's how I believe they chose to remedy it after the DA's office rejected a filing.
But they removed her from the website. Does that mean because they don't want everybody to know about this, or?
Well, she's not removed from the state licensing website.
Okay.
That is public record. She still holds a teaching credential, a license
Right.
to teach. Now, she might not be on faculty anymore with the school, which is separate, and they absolutely can
Right.
remove her because she's no longer on payroll.
But it seems that one of the reasons they're also not feeling this is a child endangerment charge is I don't think they were able to definitively prove that she was drinking, in the sense that they looked at the video of her driving and it didn't, on the face of it, look like she was intoxicated. This was an 8-month investigation where I believe they interviewed her current and former students, I believe maybe coworkers, but they couldn't establish that she was drinking or drunk while either driving to work or if she began drinking at the school. So it also feels like a case that they just had insufficient evidence, right?
Absolutely. In order to make an arrest for DUI here in California, there has to be evidence that she was impaired behind the wheel. In other words, that she could not operate the motor vehicle safely. So what does that mean? Well, you look to her driving patterns. When she pulled into the parking lot, for example, to go to school that morning, did she sway or drift or almost crack into another car? And when she parked, did she have a hard time getting out of the car? Did she have to hold onto the door to keep her balance? Did she vomit, and have to move her feet out of the way? There was nothing in her driving patterns or in her gait to suggest that she was at all impaired from the effects of alcohol. So then what are you left with? Well, you can do what's called the Widmark formula, or sometimes we affectionately refer to it as retrograde extrapolation, where if you take her blood, for example, or a breath test beyond 3 hours from the last moment in time she drove, and you couple that with her size, her weight, and whatever she had for breakfast, you can retroactively determine what her blood alcohol concentration was at the time that she last drove and pulled into that parking lot. And it sounds like that under the Widmark formula, they could not put her at a 0.08 or greater at the time she pulled in. So that's why the DA's office likely rejected the DUI filing.
But she did reportedly fail the sobriety test. So, I mean, that's interesting. And I will tell you, do you think it was interesting that it took 8 months to decide the charges would be dropped, an 8-month investigation?
It's not uncommon, frankly, especially when a defendant is out of custody. They are so backlogged right now with out of custody or what we call non-custodial arrests that there is no rush to get those matters into court and resolved. The matters that really take precedence are the ones where they are in custody because they have 48 hours from the time of arrest to get them arraigned. Otherwise, they have to release them. So they can put it on the back burner, take their time in working it up. And if it turns out they don't have the evidence, then the city attorney or the DA's office will just simply reject it and deem it to be a labor matter. Now, make no mistake about it, she still could get in trouble with the DMV. If they have evidence that, despite the lack of a criminal prosecution, that she drove under the influence, the DMV can still suspend her driver's license. So there's really almost 4 or 5 different tracks that she's up against. Number one, criminal prosecution, that was eliminated. Number 2 is her professional licensure, which is right now probably in controversy with the state. Number 3, her pension. If she would have been convicted of a job-related felony, California has pension reform where they can forfeit your pension from the date of the crime forward. So it's the consequences they never end. And then, of course, DMV involvement. The DMV gets involved. They can actually suspend or revoke your license if they feel you're a danger to the highway and you shouldn't be driving. So it's never ending. But it sounds like this lecturer lucked out for now.
Well, I got one more for you. What about a lawsuit, right? In the sense that even though charges aren't filed, we know that the standard is lower in a civil case. It's preponderance of the evidence. Could they try to, parents of these children say, we are going to either sue her or the school for allowing what they believe is a intoxicated teacher to be around our children? Would they have grounds for a lawsuit? Obviously, anybody can file a lawsuit for anything. Anybody can sue anybody, but it has to actually have grounds. It can't be frivolous. Do they have any way to file a lawsuit against the school or her on this basis, or the fact that the charges haven't been brought is signifying to them they might not have the evidence to support it?
Well, the answer is probably not. First and foremost, they have to file what's called a notice of claim within 6 months of the date of the offense, meaning you have to put the school district and government on notice that you may have a civil claim. It's sort of a mini statute of limitations. It's an administrative claim for damages. If you don't bring that claim before filing your lawsuit, your judicial lawsuit is barred. My gut tells me they never filed the notice of claim, but let's just assume they did. I believe at most all they could get is injunctive relief, maybe seeking to get her out of the classroom. But I do believe that in terms of damages, they're immunized and there would be no liability. There's no civil rights violation here. There certainly was no corporal punishment. It was an act of negligence, and there was really no monetary harm, if you will, to the child or the families.
Well, I think I agree with you that there might be a change in California law as a result of this, and maybe rightfully so. But again, at this point, she is innocent, right? She hasn't been charged. So these were just allegations that she was drinking while at school or was drunk at school. So really, Fascinating case. Like you said, she is not going to be facing charges. We can kind of have a better understanding of why. But LA County Public Defender Philip Dubé, thanks so much for coming on, and great seeing you.
Take care.
And that is all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.